Now that that is finished, let's move on to probable cause. Is probable cause going to be contested, or is there going to be a stipulation?
We'll stipulate, Judge.
Okay. The court still must make an independent determination regarding the issue of probable cause. Our Supreme Court has indicated that this is has defined probable cause as a well-grounded suspicion that the offense has been committed, and a well-grounded suspicion the defendant is the one who committed the crime. That's Gerstein versus Pugh, 420, United States 102, our 1974 United States Supreme Court case. With respect to probable cause, the court has had the opportunity to review the complaint warrant package, which includes the affidavit of probable cause and the preliminary law enforcement incident reports, which were marked and moved into evidence as S1. The court has also taken into consideration that there's a stipulation by and between the parties for the purpose of this hearing and this hearing only. Based upon those things, the court finds the defendant is an eligible defendant, that he committed the charged offenses. More specifically, that on or about September 29th, 2025, in Atlantic City, Atlantic County, New Jersey, the defendant purposely prevented a law enforcement officer from effecting an arrest, specifically by interlocking his hands tightly in front of his body, while the officer attempted to place the male in handcuffs in violation of NJSA 2C29-2A. Also within the jurisdiction of this court, purposely cause or recklessly create the risk of public inconvenience, annoyance, or alarm by engaging in fighting or threatening behavior, specifically by using offensive language and throwing rocks at pedestrians. This was in violation of NJSA 2C33-2A, which was a petty disorderly persons offense. And then within the jurisdiction of this court, threatened to commit with a crime of violence within the purpose of the purpose to terrorize the victim, Melissa, or in reckless disregard of the risk of causing such terror. A third degree offense in violation of 2C12-3A. All right. The court, having found probable cause, must move on to the issue of detention. Here, the state has the burden of proving detention by clear and convincing evidence. As I've indicated, the PSA has a 2 for risk of failure to appear and a 3 for new criminal activity, but does have a no release recommendation based upon repeated arrests while the defendant was on release. I'll hear from the state.
Thank you, Judge. As Your Honor noted, defendant scores a 2 for risk of failure to appear and a 3 for risk of new criminal activity, and that the recommendation is no release because of repeated arrest while on pretrial release. Turning to factor 1, whether the eligible defendant will not appear in court as required. While this defendant has no failures to appear in the past 2 years or any older than 2 years, he is currently on pretrial monitoring level 3 out of Camden, and the PSA does indicate that a VOM has been filed in that case. Factor 2, whether the eligible defendant will pose a danger to any other person or the community. The defendant has no prior violent convictions, but is currently facing 12 pending charges. These include 5 charges for contempt of a domestic violence restraining order, all occurring within the month of July, as well as numerous charges for theft and charges for fencing, impersonating a public servant, criminal mischief, and terroristic threats. The state is concerned that despite these pending charges, defendant has continued to reoffend and incur new charges. There is an active final restraining order against defendant, which makes his 5 pending charges for contempt of a domestic violence restraining order more concerning to the state. Similarly, the state is concerned that the events of the present matter also indicate the defendant poses a risk to the community. Here, the defendant chose to verbally threaten the victim after throwing rocks in a public area. Obtained surveillance footage even captures this behavior. And even after law enforcement arrived on the scene, defendant chose to escalate the situation by resisting arrest. Turning to factor 3, the obstruction factor. The defendant is currently on the highest level of pretrial monitoring out of Camden, level 3, yet has continued to reoffend. The PSA shows that a violation of monitoring has been filed. Defendant's failure to comply with his imposed pretrial release conditions demonstrates a high risk of continued obstruction. And because he is already on the highest level of pretrial monitoring, short of home detention or electronic monitoring, there is no higher level of pretrial monitoring that the court could impose to ensure defendant's compliance. The state isn't convinced that any monetary, non-monetary conditions or combination of the two would meet the interests of the triad. And for those reasons, the state respectfully requests that the motion to detain be granted. Thank you.
Ms. Bitters?
Judge, Mr. Wright is 57 years old. He's has currently no prior indictable convictions, no prior disorderly persons convictions, and of course, no failures to appear. He does live in Pine Hill with his parents, who are very supportive of him. He's a former firefighter. He had to retire due to a mental health diagnosis. His charges that he's currently before Your Honor on today are from September, the most serious being this terroristic threats charge. We would ask the court to just consider that this is not really the most serious charge. It's an allegation where he is alleged to have threatened to slap a Dunkin' Donuts employee. After speaking with him, it kind of seems to me just to be a really giant misunderstanding. I know he's very sorry for what occurred. He's certainly, in my opinion, not a threat to anybody, and specifically not a threat to this particular victim, as he will just not go there anymore. He does have pending charges. They all also appear to be mostly not serious, nonviolent. We would argue that he's clearly going to show up in court. He's not a risk for failing to appear. As I stated, he's not a risk to this victim, or I would argue to the public at large. And there's nothing to show that he would obstruct the process. He does appear to be eligible for PTI. I would hope that that's something that he would apply for and get and hopefully resolve with all his other charges. And for all those reasons, Judge, we would argue that the state cannot meet their burden to detain Mr. Wright.
Okay. This is, the state's filed a motion for pretrial detention, and after conducting the hearing, the court did find probable cause was established that the eligible defendant committed the charged offenses based upon the probable cause affidavit and the preliminary law enforcement incident reports that we had marked as S1 for identification purposes. Obviously, the defendant has not been indicted. What we have is a 57-year-old defendant that's facing 3 charges: a petty disorderly persons offense for improper behavior, a disorderly persons offense for resisting arrest, and then, as counsel aptly pointed out, a third-degree terroristic threats. It was a threat to commit a violent crime. It was somewhat concerning that while he's on pretrial monitoring, all of these 3 things occurred. He had 12 pending charges at the time of the offense. Out of those 12 pending charges, the highest and only one of those charges is a third-degree terroristic threats. He's got a fourth-degree contempt, and then he's got a series of disorderly persons offenses. When I read all of this, I really had trouble understanding what happened to Mr. Wright when, for 57 years, he had no prior disorderly person convictions. He had no prior indictable convictions. He had no prior violent convictions. He had no prior failures to appear. He had no prior sentences of incarceration. He's not on parole or probation. He is, and troubling is that he's on pretrial monitoring out of Camden for those cases that I've just gone over, and that VOMs have been filed on of those. He's got 1 active final domestic violence restraining order, and one of the charges is for violation of that in Camden County. But I think counsel actually shed some light on that when she told me that he lives in Pine Hill with his parents, was a firefighter, and was forced to leave that job because of a mental health diagnosis, which certainly seems to explain what happened here. What happened here is bizarre. The case is stemmed from an incident that occurred on September 29, 2025 in Atlantic City. On the date in question, officers were dispatched to the area of Atlantic Avenue following a report of a male throwing rocks and assaulting bystanders. Upon arrival, the officers encountered the defendant, Mr. Wright, who was irate and using offensive language toward bystanders. They obtained surveillance footage from the ACPD, which showed the male, meaning Mr. Wright, behaving disorderly and throwing rocks. He was placed into custody, and he passively, and that's their term, passively resisted arrest. Once in custody, that victim from Dunkin' Donuts, I guess, came forward and indicated that he had verbally threatened her minutes before. Obviously didn't act upon it. So in looking at all of this, find that the state has not met its burden by clear and convincing evidence. I believe there are conditions, non-monetary and a combination of conditions that I can set that can reasonably assure the defendant's appearance in court when required. I believe that we can protect the safety of others in the community, and the defendant will not obstruct or attempt to obstruct the criminal justice process. I understand that the PSA indicates a 2 for failure to appear, which is low, and a 3 for new criminal activity. That new criminal activity, I understand that it's improper behavior and a DP resisting the third-degree terroristic threats is a crime of violence. It's probably more of a harassment charge than it is a terroristic threats charge. I can't tell from these documents is exactly what he threatened the victim in this case with, but I believe it's ultimately would probably be a situation where it's a harassment. The non-monetary conditions for pretrial release are that you must appear for all scheduled court proceedings. You must immediately notify pretrial services of any changes of address, telephone number, or other contact information. I'm glad to hear that he's living with his parents and that they're supportive of him. You shall not commit any new offenses during the period of release. You have to avoid all contact with the alleged victim in this case. And counsel pointed out that it's Melissa. And if that actually did occur to Dunkin' Donuts, you can't go back to that Dunkin' Donuts while you're on pretrial services and release. I also, and I think that this is really important, I'm going to order that Mr. Wright shall undergo available medical, psychological, or psychiatric treatment. And it seems to me like he does have some mental health issue that has triggered this behavior. If he is under current medical treatment for that, I want him to continue with that. If he isn't on current medical treatment, I want him to be evaluated for a mental health, for his mental health, and follow any recommended treatment for any mental health condition he may be suffering from. I also, given this behavior, I'm going to have him, as a condition of his release, have him take a anger management class, which isn't a long class, but he's going to have to undergo mental health evaluation and counseling, and to undergo and successfully complete a anger management class. I believe those combinations of conditions will allow for the defendant to appear in court when required. I believe they will protect the safety of others and the community, and I believe that they will assure that the defendant will not obstruct or attempt to obstruct the criminal justice process. Therefore, I find that the state has not met its burden by clear and convincing evidence. I think those conditions, as I've set forth, will protect it. I am going to order that he be on level 3 monitoring. But I think the difference between what Camden County has done and what this court is doing is adding the conditions of a mental health evaluation and following their recommended treatment, and that he has to take an anger management class. That is the order of the court for 7 days to appeal it. I'm sorry, is there a new court date we have for him?
Yes, Judge. The next court date for us is on January 9th, 2026, before Judge Levin. Judge, when you were talking about counseling, he raised his hand. I didn't know if you want me to unmute him or not.
I'm going to let Ms. Bitters make that call. I've ruled.
Yeah, you could unmute him.
Did you want to address the court, sir?
Yes, sir. I just wanted to say that I was, as part of this situation I'm in, required to go, and I was in mental health facility until I was picked up by Camden County. So I went through I underwent an evaluation at Ancora and at One Pine.
I
And
understand. I'm
accept-
just saying, Mr. Wright, it seems to me
Understood.
like someone who, with your background and such a long period where you were having no issues whatsoever, living your life, all of a sudden something happened. I want to try and address that so it doesn't happen in the future. So you're going to have to undergo any mental health evaluation and any treatment recommendations. And I want you to take an anger management class. You've got to do those conditions. If you don't do them, they're going to violate your monitoring here. Okay?
Yes, sir.
All right, sir. Take care.